if you're charged with DWI, not yet convicted, but charged, there is an order that is entered by the magistrate if you blew over the limit or you refuse to blow, that takes your license for 30 days immediately. So when you walk out of the jail, they have kept your license and you're revoked for 30 days. And the legislature set up 2 ways to deal with that. You can be eligible for a limited driving privilege after serving 10 days of not driving. You have to jump through some hoops. You have to get a substance abuse assessment from a licensed assessor, and you have to get proof of your insurance. You'll need a lawyer to help you through that part of it. You got to draft some documents and present them to the court and get that done after 10 days, pay a $100 filing fee. There's all that to go through. In Mecklenburg County, there's actually a nice procedural trick to use. It's all legal, it's in the statute, but there's a way that I can petition for a hearing and under the right circumstances actually get your license reinstated very quickly.
Okay.
And without having to go through all this limited driving privilege process, without having to wait the 30 days, you get your license back and that revocation is rescinded. And so that's something that's not available in other counties. It's a little quirk of how our system works.
Sure.
But that's the immediate urgent problem, typically for most people when you get pulled over, is that 30-day civil revocation. The next thing that will come is if you refuse the breath test, you're going to get a letter from the DMV that says effective such and such a date, and it'll be 10 days ahead of the date that the letter's issued. Mm-hmm. For some reason, mail from the DMV in Raleigh, you get it, you've got 3 or 4 days left before the revocation begins, and it begins at 12:01 a.m. on the date in the letter. So your last opportunity to do something to save yourself is the day before the effective date. Sure. Because it's 1 minute after midnight. And so what you have to do is you have to request a hearing with DMV before that revocation starts. Okay. And if you do that, then that stops the revocation. And then there's a hearing process that you go through DMV, but during that time while you're fighting it, you keep your license. And the legislature, in their stupidity, implemented a fee system for getting hearings before the DMV. Mm-hmm. So you have to pay $450. Oh my goodness. With your application for the hearing in order to keep your license. So, and that's unavoidable at this stage. I'm waiting for the right opportunity to challenge that. I think it's unconstitutional the way they do it, the way they implemented that. But that's, you don't want to be the one having to fight that. Sure. And for now, that's what it is. So you have to have $450 within those few days after you get that letter from the DMV in order to save you from that 6 months of not being able to drive right away. So there are some ways to win that hearing. It's difficult to win that hearing, like I said earlier, but at the very least, it buys you some time, because then you can try your DWI, and there's a 1-year revocation for a first offense DWI. There's a 1-year revocation for the refusal if you get hit with that. The good news is they will run concurrently. So if you get the letter from DMV and you don't challenge the hearing and that revocation starts, and then you don't go to trial on your DWI until a year later and you get convicted, then you will suffer 2 years of a revocation. So even if you don't win the refusal hearing, it's good to postpone that while you deal with the DWI, because if you lose them both, if they start on the same day, they will end on the same day a year later. So you only suffer 1 year of revocation. So it's smart to challenge it. And like I say, a lot of times there's ways to win that as well. Sure.